Hi, I'm Kirk Evans, President of Texas Law Shield. Our 84th legislature was extremely busy when it comes to firearms laws. We're here today at this webinar to talk about several of those new laws with our program attorney, Edwin Walker. Mr. Walker is going to address several of those items, which include open carry, campus carry, and several other laws that every Texas firearms owner needs to know. With that said, welcome Mr. Walker, and thank you for attending this webinar.
On January 1st, 2016, the state of Texas allowed citizens to carry handguns in a visible manner for the first time in over 140 years. Now, there are a few qualifications in order to do this. Number one, the individual must have a Texas license to carry, and number two, any handgun that is wholly or partially visible must be carried in a belt or shoulder holster. Everyone who had previously held a Texas concealed handgun license automatically receives all of the benefits to open carry, even though their license still says concealed handgun license instead of the new designation license to carry. There is no legal difference between the two, and everyone who currently has a concealed handgun license will be issued a license to carry once they either renew their license or they request a replacement license from the Texas Department of Public Safety. With regard to the second requirement, that any handgun that becomes partially or wholly visible be carried in a belt or shoulder holster, if we look into this, there are certain ambiguities. First of all, the state did not define what is a holster, or more specifically, what is a belt or shoulder holster. Now, obviously, since there are dozens of different types of holsters, many people have had questions whether or not their holster, such as an inside the waistband holster, a belt holster, or a tactical drop leg holster, whether those qualify as a quote-unquote belt holster. Because the Texas legislature failed to define this term, all we can give you is what our opinion as to what a belt holster or shoulder holster is. We believe that a belt or shoulder holster is any holster that is designed to be worn in the waist or shoulder area. The second ambiguity arises from the fact that the law does not specify whether or not the holster must be worn on the individual who is in fact carrying it. This becomes very important if a license holder chooses to have a visible handgun in their motor vehicle. They will be allowed to have a partially or wholly visible handgun in their motor vehicle as long as it is carried in a belt or shoulder holster. With the passage of the new Texas open carry law, many people have been greatly concerned about what is the ability of a police officer to approach, detain, and demand to see the license of an individual who he observes carrying a visible handgun. Let's talk about the law just a bit here. Texas Penal Code 46.02 is the general weapons law of the state of Texas. That law says that it is a violation of law for an individual to carry on or about their person a handgun, an illegal knife, or a club, unless they are on their own property, they are in their own motor vehicle or watercraft, and if they are carrying in their motor vehicle or watercraft, the handgun must be concealed. They cannot be breaking any other law other than a traffic law or a boating law. They cannot be a member of a criminal street gang, and they have to be lawful to possess a firearm in the first place. So if a police officer does approach somebody that they see carrying a visible handgun, and they stop them and ask to see their license, they're not demanding their ID. What they're doing is they're saying, why shouldn't I arrest you for violating Texas Penal Code Chapter 4602? With the new reality that licensed Texans can now carry a wholly or partially visible handgun, this has necessitated the creation of a new law. Many license holders are familiar with the current Texas law that is commonly called 30-06. 30-06 is a criminal trespass statute whereby the owner of a piece of private property is allowed to make a decision as to whether or not they will or will not allow a license holder to bring a handgun onto their property. 30-06 covers concealed handguns. The Texas legislature has created a new statute called 30.07 that carries visible handguns. A license holder can be given notice under both 30-6 and 30-7 in 3 different ways. First, a license holder can be told verbally by the owner or somebody with the authority to act for the owner. Verbal notice has no specific requirements. It can be as simple as, we don't allow openly carried guns on the property, we don't allow any guns on the property, or you'll have to take your gun back to your car. Those would all 3 be sufficient verbal notice. Notice can also come written. If an individual is given a piece of paper or a card with a specific piece of language that the legislature has created on it, then the license holder is on notice that they are forbidden from either open carrying, concealed carrying, or both. The most common form of notice that is used is what we call constructive notice. And constructive notice is given through the posting of a sign. Many folks know these as 30-6 signs or 30-7 signs. In the event that a license holder chooses to disregard a posted sign preventing them from either concealed carrying or open carrying, they are subjected to a penalty of a Class C misdemeanor with up to a $200 fine. This is a welcome change from the previous penalty, which was a Class A misdemeanor and up to a year in the county jail and/or a $4,000 fine. However, in the event that a license holder is given verbal notice by the owner or a person acting under the authority of the owner, and they choose to disregard that notice, and they choose to stay on the property after they've been told to leave, that individual is still subject to arrest and prosecution for a Class A misdemeanor. In the event that an individual sees an unlawfully posted 30-6 sign on government property, and they have sent the government written notice, and the government has either said they will not comply or they have ignored the demand, then that individual should go to the Texas Attorney General website, and on the very first page they will see a box that says 30-6 complaints. Click on the box, fill out the drop-down menu, upload a copy of the written demand that was made, upload a copy of the picture of the sign, and send it to the Attorney General's office. The Attorney General's office will now handle the complaint from there. On August 1st, 2016, license holders will legally be allowed to walk into areas of an institution of higher learning that were previously off limits to them. This would include the library, the administration buildings, office buildings, classrooms, gymnasiums, and other buildings located on the grounds of institutions of higher learning. Institutions of higher learning that are purely private institutions are allowed to exclude license holders from carrying concealed handguns on any of their property, the buildings, the grounds, and in fact, the sidewalks, walkways, parking lots, parking garages of these institutions. On August 1st, 2016, the new law applies to all institutions of higher learning that are not public junior colleges. Public junior colleges, because many of them do have populations of high school students, public junior colleges are given an additional year to decide what places they want to make off limits to concealed carry. This means that not until August 1st, 2017 will a license holder be able to take their concealed handgun into the classrooms, the hallways, the libraries, and the administration buildings of public junior colleges. In 2015, the Texas legislature didn't just stop with allowing license holders to carry a visible handgun. They didn't just stop with allowing license holders to carry concealed handguns into college and university buildings. They also made several other laws that are beneficial to Texas firearm owners. One of the more interesting of these is that in the event a license holder accidentally carries their handgun into the secured part of the airport, before this individual can be arrested and charged with a felony, the police officer must allow them the opportunity to leave the secured part of the airport and return the handgun to their vehicle. In the event that they refuse to leave the secured part of the airport, then they are subject to arrest and prosecuted for a felony. Keep in mind, though, that this only affects Texas state law. It does not affect federal law in any way. And in fact, a license holder who is given the benefit of this law will still face administrative penalties from the TSA. Future legislatures cannot pass laws that infringe on a Texan's ability to hunt or fish through traditional methods. Of course, hunting through traditional methods includes the use of firearms. The reason the Texas legislature did this is so that a legislature in the future cannot come back and begin passing firearms restrictions that in any way infringes on the ability of a Texan to use a firearm to lawfully hunt game. Now, knife enthusiasts in certain parts of our state had their rights restricted by local laws. State law only prohibits the carrying of a knife that has a blade longer than 5.5 inches or has a double-edged blade. Therefore, Texas this year added knives to the Texas preemption statute. The Texas preemption statute is a very important law of government that says that local governments cannot pass laws that are more restrictive on the carrying, transportation, or possession of certain weapons. Firearms have been on this list for quite a while. Now knives are, which means that the local law in San Antonio, the local law in Corpus, or any other local law that is more restrictive than Texas state law with regard to the possession and carrying of knives is ineffective, and a person cannot be prosecuted for those violations.
As you can see, the recent changes to these Texas laws can impact every Texas gun owner. Thank you again for your attendance. For more information and to talk to one of your program attorneys in person, visit gunlawseminar.com and register to attend a workshop or seminar near you. Thank you.